Welcome everybody to the presentation on taking off the gloves, what to expect in U.S. Tax Court. I am Mike DeBliss. I am a partner in a law firm of DeBliss Law. We are a small boutique firm based in Bloomfield, New Jersey. And I welcome at any time if you have questions, just feel free to put them into the participant feedback, and I'll try to monitor that periodically. There is a lot of information to share with you, so I am going to jump right in to the PowerPoint. I will say that tax court is getting to be kind of a lost art, so to speak. Not many cases make their way into tax court, but when they do, the rules and the procedures of tax court can sometimes rear their ugly heads. So this is basically meant to be a primer on the rules and the procedures of tax court, how we get to tax court in the first place, and to give you some background information on the court. So unlike an Article III court, which we're all familiar to seeing on television in all of the legal dramas from Law and Order to CSI, tax court is an Article I court. It's largely self-governing. One of my law professors in law school described it as one of those like moving rodeo shows, in the sense that there is no one physical location for tax court. There are, however, 19 tax court judges that are appointed by the President with the advice and consent of the Senate, each for a 15-year term. And essentially, tax court is a traveling court. So you'll notice on the docket schedules that tax court isn't always in session, every day of the year, every month of the year. You have to kind of look at the schedules to determine when the next session of the tax court is going to be in the area where you filed the petition. The Chief Judge of the Tax Court can appoint special trial judges to hear small tax cases, those that are deemed to be under a specified dollar amount, as well as any case assigned to them by the Chief Judge. Tax court is based in Washington, D.C., but as we just talked about, its judges travel to hear cases on regular calendars in various cities around the country. At trial, and this is another huge distinction between regular courts that we're used to seeing on television and the U.S. tax court. The taxpayer can be represented by anyone admitted to practice before the tax court. So it's not limited exclusively to tax attorneys. So long as you have passed an examination with the tax court, you could be eligible to represent the taxpayer in the tax court. So from that perspective, tax court is very similar in nature to an administrative court. I do from time to time workers' compensation cases, as well as other cases that have administrative law judges that are presiding. And I would say that based on my experience, tax court is very similar in nature to those courts. So who is the IRS represented by in U.S. tax court? They're represented by attorneys from the IRS Chief Counsel's Office. And I will say this about IRS Chief Counsel. The attorneys in that office are very, very knowledgeable of the tax law and the tax code, and they have the added benefit of being lawyers. So they are no strangers to litigation. So I oftentimes, when I am counseling a client who is preparing to file a petition and making a decision on who to hire to represent them in tax court, if the case is one that is very likely going to be litigated, you want to be on a level playing ground with IRS Chief Counsel. And that's not to say that you absolutely 100% need to have a lawyer, but you want to be aware that your adversary on the other side of the aisle is not only knowledgeable in the tax laws, but is a lawyer him or herself and is abundantly familiar with the court rules. And it's always good in those cases to have a lawyer on your side to make the type of arguments that need to be made, because at the end of the day, it is a trial. It is a litigation if it gets that far. So let's talk about the rules of evidence in tax court. The U.S. Tax Court applies the rules of evidence that apply in trials without a jury in the U.S. District Court of the District of Columbia. So we don't have all of the sex appeal that we have in a Article I court, where there's a jury that gets selected and where there's a jury that listens to the case and determines the facts and then applies the law as is given to them by the judge to the facts to determine a verdict. In tax court, we have a judge who is the trier of fact and who is the individual who ultimately determines the outcome of the case. So how about procedure? The U.S. Tax Court follows its own procedural rules. After the case has been submitted, the tax court will make a report in the form of an opinion. The decision in the U.S. Tax Court is the equivalent of a judgment in the federal district court in the sense that it closes the case, it provides finality, and is the action from which an appeal is taken. So that last bit is a little bit of a precursor of what is to come. A decision in the tax court is appealable. So while it's a final judgment, it in no way, shape, or form ends the litigation if the taxpayer loses and wishes to appeal to a higher court. In that case, they can appeal to the Circuit Court of Appeals, and I'll get into jurisdictional issues momentarily. Tax court issues three types of opinions. They are division opinions, memorandum opinions, summary opinions in small tax cases. So let's talk a little bit about each type of opinion. The division opinions are those that have the highest precedential value and are officially published. So if you are used to using Lexis or Westlaw or any one of those online platforms to do your tax research, you might have come across a case from the U.S. Tax Court that has helped you to argue a point or an issue in your tax controversy in favor of your client, or you might have come across an adverse opinion. These are what's called division opinions. They're published and they do have precedential value, at least as far as the tax court in which the petition has been filed and the venue of that tax court is concerned. It may not have the same precedential value, and as a matter of fact, it doesn't if you're attempting to use a case from one U.S. tax court located in one venue to another U.S. tax court located in another venue, but we'll get to that in a little while. So tax court's first pronouncement on a question of law, this tends to be a division opinion. Court-reviewed cases. So in the event that one of the judges makes an opinion and it is deemed a division opinion, the chief judge essentially has the right to refer a division opinion for review by the entire court. So if it tends to be an issue that is of first impression and one where some of the sister circuits have fallen on the other side of the coin, the chief judge may take that lower judge's division opinion and have it reviewed by the entire panel. So this means that all the tax court judges can reconsider the case in conference after reviewing the written record. Such opinions are labeled reviewed by the court. Memorandum opinions. These have no official precedential value but are privately published. They apply clear law to new facts, and that's the catchphrase here, clear law, established law, no disparity between circuits. The law is clearly set out. It's just a matter of applying a new set of facts to the law. Summary opinions in small tax cases. They have no precedential value but are privately published. So the Chief Judge will decide whether to issue a decision as a division opinion or as a memorandum opinion. Just because, and let me just back up for a second just to give you some background information on how the case winds up in tax court. There's been a lot of developments of recent in terms of how cases are getting to tax court, but the old-fashioned way used to be that the taxpayer is audited or examined, or perhaps a revenue agent determines that there is an additional amount of tax due and owing. Typically, the taxpayer is given the option of filing a protest and having the appeals section of the IRS review the matter before going to tax court. However, it is possible for the taxpayer to circumvent appeals altogether and go right to the tax court. Now, what they consider to be the ticket to get into tax court is what is called the notice of deficiency. This is something that I know everybody is very familiar with. Notices of deficiency are routinely issued after audits and after revenue agents have determined that there is an additional amount of tax due and owing. Typically, the deficiency is the difference between the amount that the revenue agent believes the taxpayer owes less the amount that the taxpayer voluntarily reported on his or her return for that respective tax year. We could, of course, there could be additional tax years, of course, but for purposes of keeping this straightforward, let's assume that there's one tax year in question, let's assume that there's a deficiency, and let's assume that the taxpayer has been issued a notice of deficiency. That notice of deficiency is the taxpayer's ticket into tax court. Typically, the notice of deficiency allows or will state explicitly on it that the taxpayer has 90 days from the date the notice was issued to file a petition in the tax court. And so long as the taxpayer files the petition within those 90 days, then the case will be docketed in tax court. Now, just because a case is docketed, well, let me back up once more. Once a case is docketed in tax court, the tax court then will provide a copy of the petition to IRS Chief Counsel's office, and then IRS Chief Counsel will respond to the petition. We'll respond to the taxpayer's petition. So what we basically have is the IRS Chief Counsel responding by answer to the petition that is filed by the taxpayer in tax court. Now, just because a case gets docketed in tax court does not necessarily mean that it's going to go to trial. Negotiations continue, and if you just looked at one of the earlier slides, IRS Chief Counsel is the adversary in tax court. So while you might have had a dog of a fight with the examiner during the examination phase, it's sometimes refreshing to have a new face and a new party to deal with altogether on the matter. In some cases, the IRS Chief Counsel is not as emotionally vested as the examiner, who perhaps spent months and months and months involved in the audit and can't see and basically can't see any other perspective than the one that they have been glued to for the period of the examination. So it's good to have a fresh face to deal with when you get to tax court, and that's what sometimes results in movement in a case and resolution of a case, whereas it hit a standstill during the audit or examination phase. So stipulated decisions. If the taxpayer and the IRS settle a case after it's docketed with the tax court, the settlement is entered by the court as a stipulated decision. In the case where the taxpayer commences a case in tax court, only the court can remove the case from its jurisdiction. We talked about appeals from a tax court decision. So once there is a final decision by the tax court, assuming it's adverse to the taxpayer has the right to appeal it by filing a notice of appeal with the tax court within 90 days of the decision. So appeal from the tax court decision is taken by filing the notice of appeal with the tax court within 90 days of the decision. Now, not many taxpayers opt for appealing, and the reason why is because litigation is very costly, and most of the time the taxpayer has to take into consideration the deficiency versus how much the attorney fees are going to cost if they continue the litigation all the way up to the circuit level. So appellate venue, tax court appeals are taken to the Court of Appeals for the circuit in which the taxpayer resided at the time he filed the tax court petition. And that last phrase is critical to understand, at the time he filed the tax court petition, because where the taxpayer resides today may not necessarily be the same place where he resided at the time he filed the tax court petition. And it might mean the difference between whether the appeal is taken to the Third Circuit or whether it's taken to the Fourth Circuit. That's a very small difference between New York and New Jersey. Appeal of fewer than all tax years. The question here is whether the Court of Appeals has jurisdiction over a matter in which certain tax years have been disposed of by the tax court while others remain undecided. The Third Circuit rule here is that a judgment disposing of less than all claims is not appealable unless it's accompanied by a determination that the order is final and there's no just reason to delay. Deference to tax court decisions, and this comes right out of the Internal Revenue Code book as well as the procedural manual. The review of tax court decisions are comparable to review of district court decisions. And here it says U.S. Court of Appeals has exclusive jurisdiction to review the decisions of the tax court in the same way and to the same extent as decisions of the district courts in civil actions tried without a jury. Congress, however, did not repeal the predecessor of Code Section 7482, which suggests that appellate courts do not have the power to modify or reverse the tax court's findings of fact. So what all this is saying is that the facts as they are determined in the tax court are final. So notwithstanding the fact that the taxpayer might dispute the judge's findings of fact, that cannot be appealed to the circuit court for where the taxpayer resided at the time he filed the petition. So essentially, matters involving or disputes involving findings of fact at the tax court level are final, and there's no way that they can be overturned even by the Circuit Court of Appeals. U.S. tax court has jurisdiction over the following: cases involving tax deficiencies, overpayment or refund claims, declaratory judgment actions, disclosure actions, actions for relief of joint and several liability, and collection due process cases. I should specify right from the outset that if there's a refund claim, and there's no issue involving tax deficiency, the proper venue is not the U.S. tax court. If it's merely a refund claim, you have to look to another court. And the one that comes to mind right now is on the tip of my tongue, but I can't recall it. So if it's only a matter of a refund, tax court is not the appropriate venue. When it comes to tax deficiencies, the amount of the deficiency does not have to be paid or put in escrow while the case is pending. And that's one of the perks of having a case docketed in U.S. tax court. You don't have to worry about putting up the deficiency in order to get access to the tax court. As I mentioned earlier, the ticket to tax court is merely the notice of deficiency. There is no requirement to pay the deficiency or to have it put in escrow while the case is pending. Whoops. Oh, okay. Here's a question that we have. Have you ever assisted a client involved in a U.S. tax court case?
Thanks a lot, Mike. So we'll pause to give everyone a second to answer this question. This is Dave from the NJCPA. And please make sure you answer. This is how we track credit for everyone attending today. So something that is very important. We'll give people about 10, 15 more seconds, just a few more responses. And Mike, the way it's coming in, it looks like most people are answering no to this. So hopefully this is some good information for you. I guess this may come up at some point or another in your careers, and I hope you'll be able to refer to this and help your clients through something like that. And
absolutely.
We see a few more. Yep. So Mike, looks like we're going to have a few more answers. Yeah, if you're out there, please make sure you respond. We'll give you about 5 more seconds. Going once, going twice. And Mike, let me close this out for you. So what do you think about that? Most people said no. Just 1 or 2 of you said yes.
It doesn't surprise me at all because most of the time when I get calls from CPAs, accountants in reference to tax court, they are relatively unfamiliar with how things work. The good news is this. It can be somewhat intimidating and frightening if it's your first time, appearing in tax court. But at the end of the day, you're actually doing the very same thing that you were doing during the audit or the examination. You're advocating for your client. The difference, of course, is that you are in a courtroom and you're doing it face-to-face, up close and personal, if you will, with an attorney from IRS Chief Counsel's office. And if I didn't say this earlier, it has to be. It's kind of the 800-pound gorilla in the room. Not a lot of people like to pay attention to it, but the reality of the situation is that, and I can't tell you how many times I've had good luck and good fortune with this. When you have a person who is looking at things fresh for the first time and isn't as emotionally invested in the case as the examiner, it can do wonders for moving the case towards yes or getting to yes. And my experience is that attorneys from IRS Chief Counsel Office are extremely well-versed in tax law and extremely good litigators. At the same time, they often walk in with a pile or a stack of cases a mile high. And obviously I don't have to tell you that the last thing in the world they want to have to do is try every single one of them. So strategically, they pick they choose and they pick the cases that they're going to that they're going to put a fine line in the sand on, and that they're going to that are going to mean a lot to them. And in some cases, you can use that to your advantage, knowing that the Irish Council is, got all these cases. You can somehow you can use that as leverage sometimes in negotiating. So as I said, that is kind of like the unspoken word. But at the end of the day, when you walk into tax court, you'll see exactly what I mean. When people are standing in the galley, elbow to elbow, and standing room only, and you've got one judge who is getting annoyed because of all the interruptions and all the hassle, and all of these human elements factor in, and they are really the unspoken rule on how things work. All right, we'll keep moving along here. Notice of deficiency, as we mentioned earlier, is the taxpayer's ticket to tax court's jurisdiction. Tax court jurisdiction over federal tax deficiencies is based on this notice of deficiency being mailed to the taxpayer by the IRS. And again, deficiency simply means taxpayers' correct tax liability, and I'm being a little facetious here. When I say correct tax liability, that would be how the IRS views it, based on the results of their audit, less the amount that was self-reported on the return by the taxpayer. The notice. So there are special requirements that the notice of deficiency must meet in order to be legit. And so it has to, the determination, there's a determination and an explanation. So basically two elements here. It should describe the basis for and identify the amounts, if any, of the tax due, interest, additional amounts, additions to the tax, and assessable penalties included in the notice. So this is the bare minimum, and I've never seen the IRS mess this up. The notices of deficiency are really boilerplate these days, and I've never seen a notice of deficiency that has not gone into describing the basis for and satisfying the requirements of explaining what the basis for the deficiency is. Procedural requirements. The 98 Restructuring Act imposes a requirement that the notice state the latest date for the taxpayer to file the tax court petition. Courts have held that the failure of the IRS to meet this requirement does not necessarily render the notice fatally defective. And in this context, so long as the taxpayer receives a notice within the 90-day period and has enough time to respond to the notice, then notwithstanding the fact that it was not sent to the right address, but it actually got there, and the taxpayer received it within the 90-day window, then basically no harm, no foul. That's how it is interpreted. It should also, the notice of deficiency should also contain or advise the taxpayer the right to contact the taxpayer advocate's office and the location and phone number of the office. There's a last known address requirement. The notice has to be sent to the taxpayer's last known address. The Internal Revenue Code doesn't require the taxpayer to actually receive the notice because if you think about it, it would be virtually impossible for the commissioner to prove receipt. But at the same time, the last known address requirement should not be overlooked. If the taxpayer doesn't receive the notice or if he receives it late, the taxpayer cannot file a petition in the U.S. tax court. And essentially what that does is that forecloses the taxpayer from exercising their due process right to challenge the deficiency. And in the eyes of the law, whenever a right is cut off by whenever a right is cut off to a taxpayer and it's not their fault, the courts are very reluctant to give the government any pass. So to the extent that the taxpayer doesn't receive the notice or receives it late and it was the IRS's fault because it went to a different address than where the taxpayer is now living, my experience has been that the court will allow the taxpayer to still file the petition out of time. And the reason for it is because the due process right to a prepayment remedy is based on this petition, and through no fault of the taxpayer cannot be penalized and lose that due process right. Courts require the IRS to check its most recent computer records to determine the last known address. Generally, it will be the address on the taxpayer's latest property filed and processable tax return. Latest properly filed and processable tax return. There is an exception to the invalidity of improperly addressed notice of deficiency, even if the address fails the last known address requirement. If the taxpayer actually receives it within sufficient time to petition, then the notice is still valid. Explanation for the basis of the deficiency. Deficiency notices must describe the basis for the deficiency, but the failure to do so will not invalidate the deficiency. And this is what I have a real problem with. It lays out the rule here specifically that the deficiency has to describe the reason for the deficiency. But at the same time, it doesn't give the taxpayer a statutory right to the information in the notice of deficiency. At the same time, it says that the taxpayer doesn't have a statutory remedy if he doesn't receive that information in the notice of deficiency. So there's no teeth in this to enforce it or to give the IRS any incentive to be extra cautious and extra meticulous when they issue these notices of deficiency. At the same time, I will say that based on my experience, I've never seen a notice of deficiency that has not described the basis or the reasons for the deficiency. But notwithstanding this is problematic, I mean, I think that on the basis of fairness and what is right and just, if the rules state that the taxpayer has a statutory right to the information in the notice, then the taxpayer should have a statutory remedy if he doesn't receive it in the notice. Consequences of the invalidity of a notice: if the notice of deficiency is invalid or if it isn't sent for any reason, any assessment requiring a notice as a predicate is likewise invalid. In other words, the taxpayer can assert that a subsequent assessment is invalid. This is rarely the case where a notice of deficiency would not be sent. I mean, the way things are happening these days, and I don't have to tell you because you guys are on the front lines of this, but everything is virtually automated now. And to the extent that a taxpayer doesn't receive a notice of deficiency, I would hazard to guess that that would be the rare exception, because my experience has been that there is always routinely a notice of deficiency issued. Prohibition on assessment. If the taxpayer decides to litigate in tax court, there is no assessment while litigation in the tax court is pending. So that is critical because, as we will discuss later on, in other courts, and I'm thinking right now of the Federal Court of Claims, you actually have to pay the assessment as entry to litigate. You can see how tax court is more tax-friendly than some of the other courts that are available. Again, that's called the Federal Court of Claims, and I'll talk about it a little bit later on. If the taxpayer does not litigate in the tax court, the IRS will make the assessment after the 90-day period expires. So keep in mind that from the date the notice of deficiency is issued, the taxpayer has 90 days within which to file a petition. Now, I use the word issued, not received, and that is why the court rule states specifically that the expiration of the 90-day period has to be listed on the petition. I can't tell you how many times I get calls from taxpayers that are 1 or 2 or 3 or 4 days out of time because they began counting the 90-day period from the day they received the notice versus from 90 days from the time it was issued, meaning it came off the press in the IRS office. But these days, the date by which the notice of deficiency must be filed is clearly listed, usually in the right-hand corner of the cover letter of the notice of deficiency, and I'm sure you guys are familiar with the number. I'm not as familiar with numbers as of the forms as you guys are, but it's clearly listed, and in fact, I've even seen cases where it's been placed in a rectangular box to act as a constant reminder for the taxpayer. But keep in mind, if the taxpayer does not file that petition within the 90-day period, nothing is going to revive the opportunity to, or resuscitate the opportunity to litigate. The only way is if the notice wasn't sent at all, or there's an issue regarding the last known address. But if, outside of those two reasons, if the taxpayer was just lazy or negligent in getting around to it and the 90-day period has come and gone, it's too late to litigate in tax court. To initiate litigation, the taxpayer must file the petition with the tax court for redetermination of the deficiency. Again, the taxpayer doesn't have to pay the amount in dispute. The taxpayer can also claim in the petition a refund of an overpayment. At the same time, if the taxpayer is only filing a claim for refund and there's no deficiency involved, then the taxpayer must file that refund claim in federal district court. Very, very, very important. If it's just a matter of a refund claim, then the tax court is not the appropriate court. If it is a combination of a deficiency as well as a refund, then yes, tax court is an appropriate venue. The petition is a notice pleading that should be a summary statement to fairly notify the IRS as to the matters that the taxpayer contests. It does not have to be a brief. And when I say brief, I'm referring to what a lawyer would put together in, in federal court such as a motion to suppress or something. It doesn't have to be a 25 to 35 page, citation of case law. Usually, the notice pleadings are quite short, and they resemble more or less civil pleadings, where you basically number them 1 to 20 or what have you, and you basically list forth a history of the case and you describe the issues that you are disputing. Tax court rules also provide a checklist of the matters the petition should contain, and this is a great checklist to have in front of you as you're drafting your tax court petition. It's got to contain a copy of the notice of deficiency. That's pretty straightforward. It's been provided by the IRS, a statement of the taxpayer identification number, request for place of trial, and the filing fee. This $60 fee might be obsolete. It might have actually gone up since I prepared the slides, so you might just want to check that in the tax court rules. The tax court rules protect the taxpayer's privacy by excluding from public record the taxpayer's Social Security number or EIN and other private information. The court serves a petition on the commissioner. So procedurally what happens is the tax preparer or tax professional, so long as they are licensed to practice in tax court, will draft the petition and will file it with the tax court. This has been happening electronically more and more these days. And so I'll back up for a second to let you know that the U.S. tax court has basically a complete online platform. And once you become a member of the tax court, you get a login name or username and password. And most of the time, petitions are filed electronically on their server. And so you'll set up your password, you'll set up your account as soon as you receive your certificate that you have been admitted into tax court. And the beauty of being in tax court, and I'm not so sure it applies to non-attorneys who've passed the exams, but for attorneys who have been admitted into tax court, it's a lifetime admission. And I will tell you, I was stunned because I've been a member of the tax court now for nearly 7 years, or licensed to practice rather, before the tax court for almost 7 years. And I called up just about 6 months ago inquiring as to whether I had to fill out any new forms or paperwork in order to renew my my admission before the court, and they told me that it was a lifetime appointment. So that was interesting because as other courts go, you have to constantly be taking courses and extra CLEs and what have you in order to stay current and licensed before other courts. But this court, is a lifetime commitment. I'm not sure if that applies for those who have taken exams and are non-lawyers, but it's worth maybe taking a browse of the tax court website. So the commissioner, upon receipt of the taxpayer's petition, again, the commissioner receives a petition from the U.S. tax court. The commissioner must file an answer within 60 days. The purpose of the answer is to put the taxpayer on notice of what issues raised in the petition are in dispute. You'll find that what is so important when it comes to tax court litigation is narrowing the issues that are being disputed between the parties. And I sometimes think that this is a great model for cases that are that are litigated in civil court, because so often there are so many issues that are put forward, and a good number of those issues are actually agreed upon by the parties and aren't in dispute. And a lot of times there's only maybe 2 or 3 core issues that have to be litigated. But amazingly, the plaintiff lawyers will go into court, with their claws out, and they're, ready to, draw blood, at the first, a conference, or, at the very beginning of the trial, and the other party will get up and concede that, the very point that that attorney was making a big issue of is not even in dispute, and that, it's been conceded by the other side. But that's why pleadings are necessary in civil court, just as they are here in tax court. But the beauty with tax court is that if there is no dispute in issues, the judge doesn't even want them to be addressed. The judge is only concerned with those issues that are in dispute, those that the taxpayer has taken exception to. And that's why we have this pleading process where the taxpayer files a petition and the commissioner gets to answer within the 60 days. And again, the purpose is to notify the taxpayer of what issues that the IRS has taken umbrage to and will be fighting. The taxpayer then gets to file a reply to matters raised in the commissioner's answer, as to which the commissioner bears the burden of proof. A tax court case will be dismissed if the taxpayer is sent a valid notice of deficiency but files his petition late. Now, I've said that about 15 times already, but I'm trying not to sound like a broken record, but I just want to hammer this point home, because if you get the case before the 90 days have expired, and God forbid wait until after the 90th day to file the petition, you are not only has your client lost his right to exercise his due process rights in tax court, but you are going to be facing an ethics challenge, as well as a number of other issues that are going to be very unpleasant that the taxpayer could bring. So you want to protect yourself. At the end of the day, our allegiance should always be to our clients, but when it comes to our professional license and our professional reputation, that far outweighs anything. So you always want to be careful here, because this could come back to hurt you. Here's a question. Have you already met your 120 CPE credit requirement?
Thanks, Mike. This is our poll number 2 here. And looks like we got just under about 15 minutes left. And we'll give everyone just a few more seconds to answer this one. This is plain and simple. Looks like, oh wow, some of you have already finished, and you're here for the learning, which is what we love. Looks like some of you, actually, I guess the majority of you, still have a little more to go. Hopefully not too much. As you know, this is the end of a reporting period. It ends December 31st of this year, and there is no grace period or rollover or any of that. Your 120 has got to be done by December 31st. And as an announcement to everyone, I think I did hear that renewal notices will be in the mail, I believe, next week or in a week or two, so you should be getting them soon. So look out for that in the mail, because you're going to need that. It'll have the instructions on how to renew your license, which I'm sure is very important to all of you. So with that, Mike, I think we'll move on to new matters.
Cool. I'm just noticing, and I apologize, Lloyd, I looked down and I glanced at your question regarding last known address. This is a really good question. Must the taxpayer notify the IRS of changes in address? If so, why would the tax court grant leniency under due process to the taxpayer? This is a very interesting issue. I can tell you that in the tax court procedures, there is nothing that speaks to this directly. However, there might be some case law on this, because I could see the IRS's argument here being quite valid. If, for example, the taxpayer moved within that window of having of the tax court notice of the IRS notice of deficiency being mailed, that could almost be attributable. The failure to have received it could almost be attributable to the taxpayer for not having to notify the IRS of changes in address. But I will say this, and I can only say this from experience, because this is a due process right, and because of the fact that if the notice doesn't get filed within that 90-day frame, then the taxpayer loses any right to challenge the deficiency. If this were the exact set of facts where the taxpayer recently moved, I would say that the tax court probably would give the taxpayer the benefit of the doubt and allow the taxpayer to file the petition out of time. If for nothing other than the fact that this is a due process right, that and the fact but for the failure of the taxpayer to notify the IRS of the changes, he or she would have filed the petition within the 90-day time frame. But there might be some case law on that, so it's worth investigating for sure. New matters raised in the answer. This is what I like to refer to as the rotten one, Mr. Grinch. This happens, and I always advise my clients that this is a risk that you take. You file the petition, and then, lo and behold, you get an answer back. And not only do you get an answer to the issues that you raised and that you're challenging based on the notice of deficiency, but lo and behold, the IRS is coming out with new matters in its answer that weren't raised in the notice of deficiency. Is it fair? Can they do that? Well, here's some information on that. IRS can raise new matters in its answers that increase the amount of the deficiency on a basis not asserted in the notice of deficiency. It's sneaky, and I agree, and I've seen this before, and I tell you, I've grimaced upon opening up an answer where I've seen the IRS assert a higher amount of deficiency based on something that was not asserted, or based on a grounds that was not asserted in the notice of deficiency. And it's unnerving. It really is. I mean, it's almost like they're being given the opportunity to throw everything at the taxpayer, including the kitchen sink, and almost as if the taxpayer is being penalized for filing the petition. And I don't like it, not one bit, but this is how it goes. Or the IRS can raise new matters in its answers that justify the deficiency asserted on some basis not asserted in the notice of deficiency. That one can be just as unnerving as the first. The IRS can seek additional taxes not previously asserted because the statute of limitations is suspended during the period the tax court case is pending. A fancy way of referring to that is that the statute of limitations is tolled during the period the tax court case is pending. And what's interesting about that is that some taxpayers don't really understand the concept, and they think that the statute of limitations is continuing to run, notwithstanding that the case is taking so long to be docketed and to be given a calendar date. But much to their chagrin, when you sit down and re-explain it, they realize that the statute of limitations has been suspended or tolled, which is obviously favorable to the IRS, and essentially it's excludable time that's charged to the taxpayer. And so it's suspended from the date the notice of deficiency is issued. New matters raised after the IRS has filed its original answers. The IRS's ability to raise new issues after its original answer. So let me back up here. The scenario is one where taxpayer has filed his petition. He's filed his petition in response to the notice of deficiency. So he's relied on that notice of deficiency. The IRS has responded by way of answer. And now the IRS wants to raise new issues after its original answer. And this is a little bit unsettling as well. It doesn't say that the IRS is outright barred from raising new issues after its original answer. The rule states that the IRS's ability to raise new issues after its original answer is limited. And so that's another thing that doesn't really sit well with me. They limit it by rules of fairness. In my humble opinion, I would argue that if it's not in the original answer, then there should be no possibility whatsoever for the IRS to raise it in an amended answer. Notwithstanding, these are the court rules. If the IRS asserts new matters after filing its original answer, it must amend the original answer. New issues cannot be injected so late in the process that they deny the taxpayer an effective opportunity to respond. I've seen this happen before, where new issues have been raised virtually on the eve of trial, and this has been very contentious. Where the taxpayer's representative argues strenuously that those issues should be dismissed outright because they do not conform with the court rule that states that that they must be in an amended answer, and they cannot be injected so late in the process as to provide an disproportionate advantage to the IRS. The IRS bears a burden of proof with respect to new matters. New theories or grounds are not new matters. And so the good news here is that what's good for the goose is good for the gander. The taxpayer can also raise new issues. If so, like in the case when the IRS raises a new issue, the burden will be carried, in this case, by the taxpayer. If the new issue is raised by the IRS, the burden of proof will be carried by the IRS. How about discovery in tax court? It is more limited than in the federal district courts. These days, since I do a lot of criminal practice in the federal district courts, discovery is voluminous. It's like a data dump of information, and it can take sometimes as many as 10 paralegals and 3 lawyers, upwards of 6 months to 8 months, in order to organize, tens of thousands of documents that are literally dumped into a portal on the federal court's website. And, you have access codes to retrieve the information, but it is pick and shovel work, because every document could be a smoking gun, and there is, until you review each one and you understand its application or its theory to the case vis-a-vis the other documents. And again, one document might be meaningless unless it's viewed in context of another document. So the good news is that with tax court cases, discovery is more limited, as opposed to these white-collar cases involving money laundering and tax evasion that can just become absolute nightmares as far as discovery is concerned. There's a rule that comes from the Brannerton case that states that interrogatories and other discovery procedures, such as requests for admissions and depositions, are available in tax court. That's refreshing, because depositions are not allowed in the federal and state courts here in New Jersey. They are, however, allowed down in Florida in the state courts. However, they are available in tax court only if necessary after the parties have conducted discovery through informal means. And you're going to see that term informal used a lot in the tax court, because the tax court judge constantly wants there to be an open channel of communication and cooperation between counsel for the taxpayer and IRS chief counsel. And whenever is necessary, they always want both sides to be completely transparent and to provide to the other side the information that is requested, so long as it is it's legally it's something that is that the taxpayer is legally entitled to. You don't see as many disputes regarding regarding information and motions filed to compel disclosure of information in tax court, as you do in the federal courts. In federal courts, I see motions to the tune of dozens and dozens every month filed to compel the government to disclose certain information. In tax court, again, the information flows more freely. Letters making an informal request for information or for a conference to communicate informally have become known as Brannerton letters. The tax court relies heavily on stipulation of facts. And by stipulation of facts, what I'm referring to here is parties' agreement as to the facts and law in the case. This, again, is why pleadings are so important. When you take one pleading from the government or the government's answer and you compare it to the petition that was filed by the taxpayer, the judge wants to be able to see right away what the issues are that are in dispute. And if they are well drafted, they'll pop out right away, and the judge will be able to set aside those that the parties agree upon, and the issues that the parties agree upon will be stipulated to. And so parties to a tax court case are required to stipulate to the facts to the fullest extent possible. This includes stipulations of evidence, so that key documents like tax returns typically are attached to the stipulation of facts as exhibits. A party may move to compel the other party to stipulate. However, that motion must be filed no later than 45 days before trial for it to be dealt with. So while I'm talking here that there's not a heck of a lot of it's not necessary or there's not a heck of a lot of motion practice in tax court as there is in other courts, that doesn't mean that there is no motion practice whatsoever. And here is the example. If the party wishes to move the other party to compel to stipulate because the other party won't, then they must file a motion, and the judge basically becomes the umpire and will decide whether the non-willing party must stipulate. Each party must submit a short pretrial memo at the end of trial before the trial, alerting the court as to the general issues to be tried and any problems that the party anticipates to develop at trial. And so basically this is like a roadmap giving the judge a preview of the good, the bad, and the ugly that's going to unfold in the case. And again, the beauty of this is that the issues that are stipulated to are removed, and there is no time wasted on them, and you get right to the meat or right to the heart of the matter by addressing those issues where both sides are at odds. And again, this also includes issues related to evidence where certain documents might be opposed to by one party, being introduced. So this includes the whole kit and caboodle. And at the end of the trial, the judge will set a briefing schedule. So here's the difference between tax court, and we're going to end on this note, the difference between tax court and a jury trial. At the end of the trial, the jury is read the instructions and goes in to deliberate. And they come out with basically one of three outcomes, not guilty, guilty, if it's a criminal trial, of course, or they are at an impasse and the judge has to declare a mistrial. At the end of trial, and this is what surprised me at the very end of my first trial in tax court, I was expecting the judge to come back out on the bench and issue his ruling right then and there. Well, I was very surprised when the judge came out and said, all right, we're going to now set a briefing schedule for both sides. And I was perplexed because, again, I was expecting the judge to make a ruling. But that's not how it goes. At the end of the trial, the judge sets his briefing schedule, and the IRS chief counsel and the representative for the taxpayer then write briefs marshaling all the evidence and the facts that occurred during the course of the trial that were favorable to them, as well as those that were unfavorable and disputing them, and they put it into a brief. and then they submit it to the court under advisement. The briefing will include detailed proposed findings of fact and legal arguments. So you can't bend or twist things that happen during the course of the trial because obviously that's unethical. You have to go based on what was testified to or what was introduced as an exhibit, and so you have to rely on the rulings and the findings of fact by the judge. And with those rulings and findings of fact of the judge, you marshal those into arguments and you submit a brief to the judge at the end of trial. And so the decision is not instantaneously made when the parties rest their case. Instead, a brief is submitted by both sides, and then the judge will review those briefs and convene the parties to come back to court and issue his or her decision. And I think that that's where we're going to start, where we're going to stop right now. That gives you an overview of the process of how the case gets to U.S. Tax Court and kind of how the case proceeds from discovery all the way through to the end of a case. If we do get a chance later on at the next time I speak, I'd love to get into precedent applicable to tax court cases as far as what legal precedent applies and where appeal can be taken in an adverse ruling. But for now, we'll stop here.
Great. Thanks, Mike. And if you do have a minute, I do see that we have a question here. If you can address that quickly. But before we do, I just want to thank everyone for attending. This is the end of the program, so if you've got to run, I see we are a few minutes over time, feel free to disconnect. Though, Mike, if you can just stick around for this question, that would be great. And the credit letters will be emailed out in about a week or two. It will also include a link to the rest of the presentation slides so you can view them on your own. And it looks like you did have some left over, so maybe we can schedule something where we can go over the rest of these. But, Mike, you want to take a look at this question?
Sure. I have a question here about a taxpayer who receives a notice of deficiency. Are there any instances where an amended return will still be submitted to correct the deficiency? No. And the reason I say that is because a notice of deficiency is official. To the extent that the taxpayer was going to amend the original return, that had to have occurred well before we get to the issuance of a notice of deficiency. It's kind of like the equivalent of a taxpayer who is indicted on charges of tax evasion and then wants to acquiesce in paying the tax deficiency. The time to have done so has passed. That train has left the station. When you get to the stage where there is a notice of deficiency issued, it's too late to correct the deficiency by way of filing an amended return. A more probing question is, and this has come up quite frequently, where a taxpayer is being audited for one tax year, and the tax preparer has come into the know by the taxpayer of some things that were understated that perhaps border on fraud, and then based on that knowledge realizes that the most recent tax return contains the same errors as the tax year that's being reviewed by the examiner. And in that case, I've been asked questions of should we amend the latest tax year because the discrepancy in the year that is being audited is going to be discoverable by the examiner. It's not a matter of if, it's a matter of when, and it potentially has criminal consequences. And so the dilemma, if you will, is with the amended return. If we amend the most recent return, are we basically, is a cat going to be out of the bag, and are we going to do more harm than good in the sense of waving a red flag in front of the bull and and basically letting them know that there's a defect in the original in the return that's being audited. And there is no black and white, solid answer for that. Every case turns on the individual facts. I will say that generally speaking, I prefer to be as transparent with the examiner, especially, most especially, if the issue is one that is high stakes and it's just a matter of when it's going to be discovered during the audit as opposed to if. And, to the extent that it, is above an amount that would trigger a referral to CI, I want to quash that as quickly as possible. And by coming forward as early in the process of the audit as possible to be forthcoming and disclose, that tends to negate the element of willfulness, which the IRS and the U.S. Attorney's Office would have to prove as part of a tax evasion charge. And so it's a hard argument for the chief counsel or for a U.S. attorney to make to a jury that the taxpayer was willful, meaning that he was knowing and deceitful in perpetuating the fraud, if the jury then learns from the defense attorney that the taxpayer openly came forward to to amend a return while there was an audit going on for another tax year. That tends to negate the knowing and intentional and deliberate act of evading taxes. But there is no one general way or black and white answer to this. It is very strategic, and I will always recommend tax preparers to consult with attorneys who specialize in this area if there's any doubt, because at the end of the day, the most important thing, and I know that we've got our clients always squealing about paying the tax and squealing about paying our fees. At the end of the day, we do not want them to be open to exposure on the criminal level, because I can't tell you how many people have gone from complaining about paying a tax bill to staring at the possibility of being on probation and carrying the stigma of a felony conviction for a tax evasion or an obstruction charge. And when the reality of that sets in, they realize the error of their way and how the matter of paying it was so trivial and should have been done to have quelled this this issue from going any further.
Great. Well, thanks a lot, Mike. I hope everyone enjoyed today's program. I hope you enjoy the rest of the year. Everyone, make sure you get your 120 credits in. And I think most people here have signed up for this bundle that we have going on. So I think we'll see you all either on the 21st or the 27th of November, where we'll talk about alphabet soup for offers and compromise. Thanks a lot, everyone. Have a great day, and we'll see you soon.